when it is by-elections, that process can be subverted. What happens in those cases? What is happening? What do you make of what is happening at North?
Well, so was it with the Kumahu elections?
Yes.
I know that what used to prevail at the time I was at the Ministry of Roads and Highways was that, and I never encountered a by-election, to be honest with you.
Okay.
But what I came to understand was that anytime there was a by-election in a constituency, the Ministry of Roads was prevailed upon to complete ongoing projects.
Okay.
Within the constituency. And that meant that channeling resources from other areas into the constituency.
Okay.
Because the intention was to get the sympathy of the people, get the people to understand that government is working.
Okay.
But what is happening now is even more. It has been escalated.
Okay.
I mean, so it was ongoing projects. So you give those projects, you focus more attention on those projects to see that within the period that the by-elections will take place, there will be substantial improvement in the roads. But now we see that they are even awarding new roads. They don't do feasibility. The road construction itself violates many of the fundamental principles of road construction. There's no base or sub-base. In the Kumahu case, I hear a particular road was constructed just by clearing the road and pouring bitumen on it. No building on the road. And that's why contractors and engineers have said that it will be surprising if the roads in Kumahu last more than 1 year.
Because the roads were not constructed
properly. And so, and then immediately thereafter, we have the North elections, and they packed bag and baggage there. They are repeating exactly what they repeated and what they did in Kumahu. How that will help them, I don't know. But my problem and concern is simply the resources that we are wasting.
Okay.
Not that it's wrong to build roads for people of Asin North, and not that it's wrong to build roads for people in Kumahu. It's just that we are not employing the engineering principles and methods, strategies to build a road, and that we might be pouring more money down the drain. And we are in difficult times, dire straits, and that is my worry.
So your worry is, so as we speak now, you can say for a fact that the roads that they are building are not built to last. They're just
no. They're just
give
built
an impression that we are working on it.
They're just built to attract votes.
Okay.
Yes. They're not built to last. And that's willful. Also, that's willful.
So that's one of the things they call willfully causing financial loss to the state.
That's willful.
You knew and you did.
Yeah.
Intentionally for the votes.
Yeah.
But that's not. We've come to this because of what has happened to Honorable James Gyakye Quayson, the Supreme Court's decision. I'm sure you were in Parliament when this Adamu Sakande matter happened.
They are not the same. That's why I've said that people should not advance stupid arguments to rationalize what has happened to Gyakye Quayson.
Okay.
Adamu Sakande, while he was alive and in Parliament, had 3 passports. He never renounced his citizenship.
At the time, he was still sitting as a member of Parliament.
He was traveling at will on those passports.
Oh.
So how can you equate that to Gyakye Quayson? The brief facts of Gyakye Quayson's cases. Between September 2019 and October 2020, he put in an application to renounce his Canadian citizenship because he was preparing himself to contest the Asin North elections. Come COVID, the Canadian authorities were not working full-time. They had reduced workforce to be able to contain the spread of the COVID. However, when he put in his application was acknowledged.
Okay.
And he was assured that the Canadian authorities were working on his application. Then come October 7th, the Electoral Commission opened nominations for parliamentary elections in the Asin North constituency. When he picked form and wanted to submit for the elections, he was challenged by an MPP member. He produced documents showing that he had renounced his citizenship of Canada. The Electoral Commission examined those documents and came to the conclusion that those those documents were enough proof that Gyakye Quayson had renounced his citizenship. The nomination for parliamentary candidates in the Asin North and in the whole of the country closed on the 9th of October. On the 20th of October, Gyakye Quayson received his certificate of renunciation from the Canadian authorities 11 days after the closure. The Supreme Court decision turns on the fact that between 7th and 9th, when nominations opened, Gyakye Quayson did not have a certificate of renunciation. So how can you compare that to Adamu Sakara? How can you? So you took steps. Gyakye Quayson took steps, reasonable steps, long before nominations were opened. In 2019, he took those steps. Now, he was challenged. He submitted documents evidencing his renunciation of the Canadian citizenship to the electoral authorities. They examined those documents and were convinced that those documents were enough proof. So what is the fault of Gyakye Quayson in this? What is the fault?
The Supreme Court said he should have waited to take a certificate.
That's what the Supreme Court says. So the Supreme Court is using a strict constructionalist approach and felt bound by a decision they had given in the Zenato case, where they said that a person can only challenge the eligibility of a person. You know, Zenato had been, it had been said that Zenato was not a registered voter in the constituency, and so he was otherwise unqualified to contest as a parliamentary member of parliament or parliamentary candidate, the parliamentary primaries of the Osu Klote constituency. The Supreme Court ruled that the only time that you could challenge the eligibility of a person to contest in the parliamentary primaries or parliamentary elections was when the nominations was opened. And insofar as nominations were not opened, I mean, the challenge was premature. Yeah. Okay, so they relied because they had given an indication that this is the time.
Okay.
But they have not given us the indication of a bandwidth within this time. It just said when nominations are open. And so they relied on that decision and disqualified Gyakye Quayson. I have said that if they had averted their mind to the modern purposive approach to the interpretation of the Constitution, in the case of Gyakye Quayson, they would have come to a different conclusion. Because you will see clearly this is a person who took steps way before nominations were opened. It normally takes the Canadian authorities 3 months to process a renunciation. Okay. I mean, it took more than 1 year. Why? COVID. Can you hold Gyakye Quayson vicariously responsible for the inability of Canadian authorities to issue him or to go to work? No. Our laws in Ghana frowns upon vicarious responsibility for the commission of an offense. Okay, so now, in fact, strictly speaking, we are holding Gyakye Quayson vicariously responsible for his inability to produce a certificate of renunciation, which was not given to him by the Canadian authorities. That's why I'm saying that if you looked at the modern purposive approach, and what is it? They will say that, so if at the time of, assuming at the time of opening nominations, a person is not declared a certified lunatic, he's of sound mind, then immediately after nominations and after parliamentary contest, he becomes insane. What happens? But not before he is sworn into parliament. What happens?
That would be an interesting case.
Yeah, so
for us to look at. But there are those who also point out that you recall, I think somewhere, was it 2016, when Dr. Papa Kwesindum and some other candidates were actually disqualified by the Electoral Commission led by Madam Charlotte Osei at the time. When they went to the Supreme Court was of the opinion that nomination was a process.
Yeah, and that they should be given fair opportunity to complete.
Yes. So they are both say they are contradicting themselves in the two different rulings.
I don't want to sound again what I said when they issued the injunction against Gyakye Quayson. We said he should hold himself. He's prohibited from holding himself out as a member of parliament and restrained from attending parliament. I said, how can you make that decision? You have always said that is entitled to be presumed innocent. Is entitled to this entitlement or presumption of regularity, that everything went on well until you find out otherwise. He's in the Supreme Court. He has not yet been pronounced. And you say, go, even before, don't go. I said that was, to the greatest respect to my Lord Justices of the Supreme Court, that was jurisprudence of convenience. In one instance, you are saying that you can't stop a person from attending parliament until you pronounce. In another instance, you are pronouncing. And the example you have given, you've said in the Papa Indum, Nana Kulodo Ajima Rollins and others case, you said, oh no, it's a process. And even these infractions can be corrected. And so they must give them an opportunity to remedy the infractions. In another case, he said, no. Never mind that he got his certificate of renunciation 11 days after nominations had closed. Is disqualified.
Yeah, you call it is it
jurisprudence of convenience?
Jurisprudence of convenience.
Yes.
Convenience to who?
Well, when it's convenient to rule.
But then having said that, because you said they are holding, you said vicariously responsible.
Yes.
Because in this matter, if you read the Daily Guide last week and a few papers, they seem to be drawing the attention of the constituents to the fact that he's standing prosecution.
Oh yeah, but prosecution, standing
might
prosecution.
Be jailed.
No, standing prosecution is not one of the conditions under which a person can be prevented from contesting elections. So I'm actually shocked that papers and people and some lawyers are actually advocating that. Maybe those lawyers are concerned that if the worst comes to the worst, we might again go for by-elections. But so be it. Because, I mean, this is a country of laws, and the rule of law must prevail at all times. The Gyakye Quayson has met all the requirements under Article 94 of the Constitution. All the requirements. As we speak, there's nothing holding Gyakye Quayson away or preventing him from contesting that setting of elections. So on what legal grounds can you prevent him from contesting? What legal grounds? Now, when you come to the morality of the issue, I am of the view that Gyakye Quayson has been hard done by the Supreme Court. Because actions must be backed by intentions, not so? You have the circumstances surrounding his case show conclusively that this is a person who is a useful and responsible citizen of this country. That at any point in time, he's been alive to his responsibilities to uphold the laws of the country. But circumstances made it impossible. Circumstances out of his control made it impossible for him to meet the strict requirements of the law. And those circumstances were not in his control.
Okay.
That's why I say if you use the modern purposes approach and you read philosophy, it is important that in assessing human conduct, benevolence, compassion, empathy, understanding must animate your thoughts. Tell me, if you put Sana, assuming that you were working in Canada, you put in your application because you want to contest the Ketu North seat, and then your application is being processed. Tell me, how is it that you can influence the expeditious processing of our application? Is it within your power? And he did the application long before the nominations were put. So, and what is the purpose? The purpose is that the purpose of that provision of not owing allegiance to another country is simply that while performing your duty in Parliament, you must not owe allegiance to another country. While performing your duty, you can't perform your duty in Parliament while you are owing allegiance to another. That's the purpose of that provision.
Okay.
That's the purpose. You can't occupy the office of Parliament when you owe allegiance to another country. That's the purpose. That's the purpose. You can't be serving two masters
at the same time.
At the same time. That's the purpose. So if we come to the purposive approach, first of all, Gyakye Quayson got his certificate of renunciation before the parliamentary primaries. The question that begs an answer is, or begs for an answer, is if Gyakye Quayson had not won the parliamentary elections of Asin North, will he have been sent to court?
I'm not sure.
Now, but even before he contested the parliamentary elections, he had a certificate of renunciation. Before he was sworn in,
he had that certificate.
At that point, he didn't owe allegiance. There was evidence, abundance of evidence that he didn't owe allegiance to another country. When he assumed his seat in Parliament, he didn't owe allegiance to another country. A person shall not be a member of Parliament if he owes allegiance to another country.
So to you, at the time when he was a member, it could have been said to have been a member of Parliament, he didn't owe allegiance to him. That should have been the point.
Because it's about eligibility for a member of Parliament. That's the point. So if someone is elected today and forges a certificate and says that he's more than 21 years old, and we elect him, he gets into Parliament, then we finally have documents. We go to court to say that at the time of his elections, or he's sitting in Parliament, he's not 21 years. You have to go to court because you can't sit in Parliament. You're not qualified. Or if there's a certificate, if there's evidence that a person has been declared a certified bankrupt somewhere else, the law doesn't say in Ghana, somewhere else, and the information did not come to us early enough after diligent search that he was declared a certified bankrupt. Then he wins his seat, takes his seat in Parliament. The information subsequently comes. We can go to court. There is an undischarged bankrupt. So that's why I believe that if the Supreme Court did not feel bound by its earlier decision, probably they would have come to
a different conclusion. Well, I have 4 minutes to go, but I want to just take your view on this because you were deputy minister in the Mills administration. So you knew that administration quite well. Now, last week, Daniel Dormelevo also, the decision came and that administration was called in because of what the MPP said was a precedent set by the Mills administration when they issued a green letter to Edward Duajiman to leave office as the Auditor General. That based on what the Mills administration did, they copied. The MPP copied what the Mills administration did and decided that Daniel Dormelevo too, his time had come, so he should also proceed on leave. That what they did was only to follow.
So that's why I'm saying that with the greatest respect to you, that those who make that argument are making a stupid argument. Why? Duajiman was appointed by President Kufuor when he was president. He has served the useful term of office. He had gone on retirement as an Auditor General. His retirement was extended, under Kufuor, and further extended the second extension. It was during the second extension that Atamils won the elections. Okay, and Atamils said, "Oh, I don't want to sack you, but you're a public officer. I think that you should take your accumulated leave." Okay, this was a person who had been brought out of retirement to occupy the office. Even when Atamils wrote that letter or directed that letter be written, PC Afio Ofori, who was in parliament with me, went to court. Do you know that he went to court?
No, not that I recall.
To challenge the constitutionality of the letter. The court said Atamils had acted properly because he was a public servant. At that point, under Article 199, he had taken the benefit of a public servant because his term of office had been extended for him. So he was a public servant. And Mills was right in asking the public servant to go on and that it was legal and proper. The decision is there. PC Afio Ofori against the Attorney General. Whoever wants to go and pick it and read. How does that compare with Dumelevo? So, okay, so there was that green letter. If the president is the green letter, and I've seen them circulating it and read it too. And reading any time that you mention Dumelevo, they pull the green letter as their defense. I've seen them reading the green letter. But you see, when the green letter was sent to Dumelevo, he drew the attention to the president that what he was doing was unconstitutional. And that the president should to hasten slowly. In fact, that letter, that's his response to the green letter. The response of Dormelevo to the green letter emanating from the president's secretary, Bidia Tuo, attracted the eye of the president. He escalated the leave from 1 to the 2 to 1 to 7 days.
Yes, I recall.
That's impunity. And if I hear people saying that, well, you can impeach the president, you must establish willfulness. Tell me, if this is not willfulness, then what is it? The deliberateness in the act of impunity is nauseating. It's nauseating because you see, he had his attention was drawn to it. He didn't say, okay, let me look at it. He didn't say, well, I'm convinced that you, as a public officer or as Office of Auditor General, you are entitled to go and leave. He was so annoyed that the Auditor General, who is not a lawyer, was telling him, a lawyer, that he was breaching the Constitution.
So he added more.
He punished him more. No, but why did he do all this? So, do you see why that is not the same? Again, the different circumstances. This man was in office, Atamil said, go and leave. But this man, Dormelevo, and I sometimes feel extreme sympathy for him. Because I left office in 2017. Dormelevo did his special audit of ministries, departments, and agencies in 2017. The first State of the Nation address of Nana Addo Dankwa Akufo-Addo, the president of the country, included huge excerpts from Dormelevo's Auditor General's report, which was not yet before Parliament. So sometimes I see that the inconsistencies in this government is ridiculous. Attorney General says you can't publish covert audit reports without laying it before Parliament. The first State of the Nation address given by His Excellency Nana Addo Dankwa Akufo-Addo contained large swathes of the Auditor General's report, which had not yet been finalized and laid before Parliament. And I commented on it, so I know what I'm talking about. So this is the darling boy of the president. He was so convinced that Dormelevo was going to help him to protect the public purse. After all, he had sworn at the Black Star Square that he was going to protect the public purse. And the only mandated constitutional office that could help him to do that was the office of the Auditor General. So the Dalam boy, he fell out of love. Dormelevo fell out of love when he decided to go after another Dalam man of the president, Osafo Mafo. Because he had come to the conclusion that the payment of 1 million to Kroll and Associates was otherwise unlawful expenditure. And so Osafo Mafo must be surcharged. He was hunted out of office. Do you know they barricaded his office?
Yes, I recall.
And then they appointed an Auditor General, acting Auditor General. And the next day, the acting Auditor General wrote a letter to Parliament and said that the Auditor General was satisfied that the expenditure by Osafo Mafo was otherwise legitimate. That was the purpose of hunting him out. And you say this is not willful? It's even reckless to the extreme.
I wish I had Alhaji a bit earlier because there are several issues I wanted to raise with you, but I have to make way for Chami. I've already taken too much of his time. Alhaji, thank you very much.
You're welcome.
Yeah, when you come into town the next time, let me know.
Okay.
So that we can work something out.
Okay.
Alhaji Inusah Fuseini is former member of Parliament for Tamale Central. Always wonderful hosting him. He's a friend of the Gold Morning Conversation.
Gold Morning.
Yes. We are done for today. Ochami Bajumba is up next with the mid-morning show.
Kofi guys, Eddie, Ewa, Sombo. Go. Osode. Eddie na mi wi. Wo na wasi nantia wo kwai. Osode.